Prosecutor here?
Yep.
Hello.
Let's go over with all my part.
Ready on Daryl Dorchy. Calling case number 2061683. The people of the state of Michigan versus Daryl Dorchy. Defendant is charged with count 1, homicide, murder, second degree, habitual offender, court notice, mandatory 25-year sentence. This matter is scheduled for examination.
Good afternoon, Your Honor. Adam Dreer, P 79246, for the people.
Renee Cooper for the defense. We're ready to proceed. We ask witness is not testifying. He's requested.
Your Honor, the only exception, I have the officer in charge in the courtroom for my assistant.
Is he testifying?
I don't believe his testimony will be required today, Judge.
Okay. Was there any objection?
None.
All right, any other witnesses testifying today at trial, any hearing will be the courtroom or be denied as to the testimony. You give exception to the officer in charge. All right, any other preliminary issue?
Yes, Your Honor, before we begin, the people have marked what's been labeled. Oh,
Do you have any other exhibits tomorrow?
no, this may be on.
Okay.
Your Honor, it's been marked as people's proposed exhibit 1. It's a copy of the medical examiner's report provided, or excuse me, signed by Leah Haverty, MD, Deputy Chief Medical Examiner. I would move for its admission at this time.
With no objection.
You have minutes for example? No.
It's also my understanding that opposing counsels would stipulate the identification of the body.
That's true.
All right. Or we'll accept that information.
Does the court wish me to read the summary and opinion into the record?
Yes.
It reads, it is my opinion that death was caused by stab wound to the chest. There was a stab wound on the left chest. The wound tract passed through the left chest wall, pericardial sac, and into the heart. There was extensive bleeding into the chest soft tissue and combined chest cavities. The wound tract was from front to back and left to right when the body is viewed in the standard anatomical position. There were 4 incised wounds or cuts on the right palm and right thumb, indicating that a struggle had occurred. Other injuries included abrasions on the left forehead, right chin, front and both sides of the back of the neck, top of the right shoulder, back of the right third finger, and back of the left upper arm. Bruises were on the inside of the lower lip and lateral right upper arm. A laceration was on the inside of the upper lip. The manner of death is homicide. And as I mentioned before, that's signed Dr. Leah Haverty, MD, Deputy Chief Medical Examiner, November 6, 2020.
Name.
As Isaiah Jerome Collins, Your Honor.
Could I just have 30 seconds to give my client?
Sure.
ready, Judge.
Officer Mitchell.
Step up there, please. Excuse me, raise your hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Before the door starts, you have to speak. Proceed.
And would you please introduce yourself for the record?
I am police officer Ariana
Where are you a police officer
at the 12th precinct.
Is that for the city of Detroit?
Yes, it's located at 1441 West 7 Mile.
How long have you been a police officer for the city of Detroit?
For a year now.
Were you working in that capacity on October 26th of 2020?
Yes.
And then was there a time that you were dispatched to a location on Covington Drive?
Yes.
Do you remember approximately what time of day that was?
No. I don't.
What did you discover when you arrived there?
When I arrived, I saw the victim facing, he was face down on his stomach with shirtless with a pair of jeans on, blue jeans.
What was he face down on?
He was on the grass.
So can you describe the area for us a bit?
It was in front of the address 757 Covington on the side of the building. Face down on the grass.
What did you do after you arrived there?
I canvassed the area to see if there was any witnesses, and then medics came.
Now, ultimately, this location is within the city of Detroit,
Yes,
and it's in the county of Wayne.
yes.
I have no further questions for this witness.
I have no question.
All right, thank you.
Okay, wait, hold on. Okay.
Thank you.
Is that the witness be excused?
No objection to that.
All right, thank you.
You call Sergeant Benatic.
First name.
Matthew, 2 T's, G-N-A-T-E-S.
Step up there. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
And the truth, and what question?
Thank you, Judge. Sir, if you would please introduce yourself for the record.
Sure, Matthew Genetic.
Are you currently employed?
I am.
Where?
Sergeant with the Detroit Police Department Homicide Unit,
How long have you been employed with the, city of Detroit?
24 years.
And were you employed in that capacity around October of 2020?
I was.
Did there come a time when you were involved in a case involving Mr. Daryl Dorsey?
Yes.
When did that occur?
I believe it was October 28th, but I'm not 100% sure, but I believe it was maybe the 27th.
What was your involvement with the case?
I went to the scene as well as interviewed Mr. Dorsey.
When you say you went to the scene, what scene did you go to?
There was a scene at Merton and 3rd.
What did you do at that?
Merton and 3rd.
What did you do when you arrived there?
Met with the responding units and then basically directed the evidence tech units.
Did there come a time when you entered into an apartment?
Yes.
Whose apartment did you enter into?
Mr. Dorsey's.
Earlier you testified you directed evidence techs through the apartment.
I did.
Could you tell us a general layout or the condition the apartment was in when you arrived there?
Okay, I need the foundation. You know, you went through the defendant's apartment, I need the foundation. He had a warrant and he had a right to go in.
Oh, yes, Judge.
Okay, without that, I can't take any of it.
Yes, Judge. Sergeant, do you know what time officers were originally dispatched out to the scene?
I don't recall.
Do you know how long after the initial dispatch occurred that you arrived at the scene?
It usually takes, I can only speculate, an hour or two.
At some point before entering the apartment, did you obtain a search warrant?
Yes.
How did you obtain that?
One of the members from Homicide, Western Unit, did a search warrant.
And it was approved by the independent magistrate?
Yes.
And after receiving that warrant, did you then enter an apartment?
Yes.
Now, can you provide just sort of a general layout or a condition of what the apartment was in when you were inside of it?
I think when you entered, you're in a common area like a living room. There's another area that's like, I wouldn't even call it dining, it's a very small apartment. Kitchen to your left, bedroom and bathroom to the right.
Was it clean?
No.
Were there any items that stuck out to you?
Without refreshing my recollection from my report or photos, I don't recall exactly. I know we photographed some items as well as collected some others.
Did you personally collect any of them?
I did not.
Earlier, you also testified that at some point you interviewed Mr. Dorsey.
Yes.
Is Mr. Dorsey present in the courtroom today?
Yes.
Could you please point to him and identify an article of clothing he's wearing?
Sure, he's seated back there with the gray jumpsuit and the blue mask.
May the record reflect the witness has identified Mr. Dorsey. Do you recall when this interview occurred?
That was on the 28th of October, 2020.
Do you recall what time of day it was?
I believe it was about 11:40 a.m.
Where did this interview occur?
at the Detroit Detention Center.
Was it in a room of some sort?
Yeah, it's one of the interview rooms.
Prior to interviewing Mr. Dorsey, did you have an opportunity to advise him of his rights under Miranda?
Yes.
1 second. Mr. Cooper, are you willing for exam purposes only, willing to stipulate that your client received, understood, voluntarily waived his right to commit a sin?
I would be, I'd like to make sure that Mr. Dorsey sees it. I don't think we should stipulate that.
All right, go ahead.
Yes, sir. Thank you. Officer, are the Miranda warnings something that you have memorized?
I can wing it, sure.
But ultimately, is that how you proceed when providing an individual Miranda warning?
No,
How do you proceed under that?
we have a constitutional rights form that we use in the Detroit Police Department.
And what procedure do you follow in order to ensure that somebody understands the rights that they have under Miranda?
One second. Well, one, I just need to,
Can you explain to him, let's put your mess up. He can't be talking while everything's going. He says it's.
Mr. Dorsey, leave your mask on. The only person you're gonna talk to right now is your attorney. All right? If you disrupt my proceeding in any form or fashion, I'll just send you to the back, let you sit back there, then when it's all over, I'll let Mr. Cooper come down and tell you what happened. Do you understand?
Yes, sir. It would be really easy, Judge, too, if you could tell Mr. Dorsey what the purpose of this hearing is.
All right. Mr. Dorsey, this hearing is what we call a preliminary exam. It's a probable cause hearing. I just make a determination on whether there's enough evidence, and the standard is probable cause. It's not like a trial. Trial is beyond reasonable doubt, all right?
Yes.
This is probable cause. If there's any evidence that says a crime was committed and you had something to do with committing it, that's it. Once I get that, it's over. Matter of fact, once I get that, I usually stop it. All right? We don't go into a whole bunch of other stuff. I don't need to. I'm not here to make determination. I don't make a determination of whether you're guilty or innocent. All right? That's not my job. My job is just to make a determination whether there's evidence that can associate you with the crime that you're charged with. That's it. You understand each other?
Yes, sir.
Thank you. Thank you. Hey, Counsel, your line of questioning was, what do you usually do? I don't care about that.
Yes, sir.
I only care about what you did in this instance.
Yes, sir.
Did you present, blah, 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 or what did you do in Yellowstone? Okay?
Yes, sir. Earlier you mentioned this constitutional rights form. Did you provide a form like that to Mr. Dorsey?
Yes,
And did you have him read the form?
I did.
What manner did he read the form?
Allowed.
There also something that he must do himself on the form?
I asked him to initial next to each one of the lines, as well as affix his signature with the date and time.
Were you able to determine if he had any prior experience with Miranda warnings?
I don't recall if I asked.
Did you ask about his education level?
I did.
And when you listened to him read the warnings out loud, did you have any indication he had trouble reading?
No.
Did you have any indication that he didn't understand his rights under Miranda?
No.
At any time, did you force him to speak to you?
No.
Did you make any threats for him to speak with you?
No.
Was it your understanding then that he waived his rights under Miranda?
Yes.
And that occurred prior to you speaking to him?
Correct.
Now, once you began speaking to him, how did your conversation begin?
I think I just asked him, hey, can you tell me what happened?
Did he explain what happened?
He did.
What did he tell you happened?
Wait, before you get to that point, of course, we'll have to make a ruling on the voluntariness and the constitutional rights. You
I appreciate that, Judge. I'd like a little voir dire, please.
Okay.
Sir, I'm noticing that this was the 28th of October of last year, am I correct?
Correct.
And was that the first, was this statement taken and apparently signed, was that the first contact you had with Mr. Dorsey?
I don't recall if I had any contact with him prior to it, but I know that was the first time I got to Miranda and spoke with him.
Okay. How long do you know how long he had been in custody before you took a formal statement from him?
I don't, it had to be within 48 hours.
I think it was maybe.
No, I know it was within 48 hours.
Okay, so you know, you also know it was at least overnight.
Sure,
Okay, and you know it was over 2 nights.
that I don't know.
Okay, so we know 24 hours.
I'll give you that, sure.
Okay, and do you know where he was kept during that time?
Just at the normal DDC facility where they house prisoners.
And that's in a cell then?
Correct.
And do you know what he was given to eat or drink or anything like that?
I don't know.
Do you know anything about his sleeping conditions? Was he able to sleep or was it too much noise?
I don't.
Okay. And did you discuss those issues with any other officers?
I don't recall having any discussion about that, no.
Okay. Did you tell Mr. Dorsey that after he gave you a statement, he could just go home?
Absolutely not.
Okay. At one point, he did just go home, right?
I don't recall. You're telling me that we released him?
Yeah. You don't remember that?
I don't.
Oh,
If you're telling me that that's what happened, then I'm not gonna argue with you, but I don't recall that happening.
well, okay. I don't know exactly what your position was on this. Do you recall telling him to come back and pick up his wallet and other belongings?
Sure, now I do, absolutely.
Okay.
We have a lot of cases, I apologize, I'm not trying to
That's okay. I'll give you
Okay.
something to remind you. And then
I appreciate
it. So when he came, so clearly he was gone home. He was
Sure.
gone. You contacted him, he came back voluntarily,
correct.
and problem was, it really wasn't to give him his wallet, it was to arrest him.
That's fair.
Okay. And was that based on the statement that you took on the 28th?
I don't recall, like, I'm not the officer in charge of the case, I recall it possibly being, we ran out of time, and we had to release him. We didn't get, have enough time to get the warrant secured. I don't know if that was a linchpin or what, I just don't recall.
Okay.
I'm not the officer in charge, I apologize.
That's all I have.
Another quick question. Did you deny, Mr. Dorsey, water or food?
No,
Did he ask for any?
no,
And, did you ask him if he was under the influence of any kind of, drug or alcohol?
I don't think I asked him, no.
Okay, and did he appear to be?
He did not.
Did he answer your questions, that you posed to him
Yes,
in a rational manner, so you seem to understand your question?
we did speak back and forth, yes.
Okay. Any questions based on my question?
No, Your Honor.
No, thank you, Judge.
All right, the court at this point is going to find that the defendant did in fact receive, that he understood, and that he waived his constitutional rights and made a statement. And that's for that purpose.
Thank you, Judge. When you asked Mr. Dorsey what happened, what did he tell you?
He said that he and Mike, who the decedent got into, as he knew him as Mike, got into a physical altercation further down the block. He then was down towards Merton and Third, where our scene was, when Mike approached him, re-engaged, and they got in a fight. He produced a knife and stabbed him. And those are my words, obviously. I can't give the exact verbiage that he used, but pretty much.
Were you able to provide him with any sort of information or at least confirm that Mike is the same individual from the scene?
Yes, I don't remember how we did it, but I do know that we knew we were speaking of the same person.
Did the defendant tell you what his condition was at the time of the murder?
As far as,
Judge, is quite vague, mental, physical. When you say condition, I don't know.
All right, can you clarify?
I will, Judge.
Thank you.
Did the defendant ever mention whether or not he had been drinking on the time of the incident?
he did.
What did he tell you?
He said he was drinking.
Yeah, I have no further questions for this witness.
Just a few questions, sir. Okay. When you began to ask Mr. Dorsey what occurred, one of the things he made clear to you was that the fight started in front of their apartment building. Is that correct?
I thought he said the original fight started down the block. He
Okay.
described where it happened further towards 6 Mile on 3rd.
Okay, and you found out their apartment building, the one they both lived in, was further down the block on Third.
So I think there's a confusion. There was an original fight between these two, according to what he told me, and then it comes to the 3rd and Merton area where the stabbing actually took place.
Okay.
Just to clarify.
Well, the original fight, it was made clear to you that this younger, more healthy man beat up Mr. Dorsey.
That's his statement.
Okay,
Yeah.
well,
That's
that's
what
what
he's
we're
telling
talking about. That's all you have, right?
Sure.
We're working with his statement only. I thought, you have no eyewitnesses, am I correct? That you know of?
That I know of, correct.
Okay, so we're working with what he said occurred.
Okay.
And he told you that he got beat up badly by the man we're calling Mike.
Okay.
Did he not tell you that?
He did. He said he got in a fight with Mike.
Right, and then he ran away. He left and went to the spot on Third.
Okay.
Isn't that what he told you?
I'm agreeing with you, yes.
Okay, and then when he left, he looks around, and here comes Mike, coming to get some more. Didn't he tell you that?
I don't remember the exact words, but I know that he came back down to where our suspect was. Yes.
Okay, he's leaving, he's walking away, he's like, I'm done fighting, and Mike is chasing him, right? And then, don't you remember him telling you, I pulled out the knife. I didn't think Mike would run into the knife.
Yes.
Yes, that's all I have, thank you.
Okay, good.
Okay. Nothing further.
Step down.
Thank you.
Any further witnesses?
No, Your Honor, people have no further witnesses.
Defense?
We're not calling anyone, thank you.
All right, thank you. All right, argue.
Your Honor, the people come here today with a one-count complaint alleging murder in the second degree against Isaiah J. Collins. I have noticed that the first name on the warrant and complaint reads 2 A's as opposed to the AH. I would just ask briefly for that to be amended going forward, should the case go forward. But ultimately, the people have provided evidence not only that on October 26, 2020 in the city of Detroit, a stabbing occurred, but also that Mr. Dorsey was the one who committed the stabbing. I believe People's Exhibit 1 at least provides this court with sufficient evidence as it outlines that it was the opinion there was a struggle with multiple incised wounds in a defensive sort of capacity on Mr. Collins' body. And then the single stab wound to the chest, penetrating his heart. Ultimately, it's the defendant's statement himself that places him at the scene. And certainly, at least what has been provided today, outlines that during this fight, the defendant pulled out a knife and finished the victim. So I would ask the court to make a finding of probable cause to believe that the murder in the second degree occurred, and that it was likely that the defendant committed it, and ask that this court bind the charge over to the circuit court for trial. Thank you.
Wait, one question. The testimony, basically, the only thing we have that connects the defendant to this is the statement, his own statement. I understand I didn't get all of the statement, but you didn't go through the video or whatever. But what I did get out of it is that he and the deceased got into what he knows is Mike. Got into a physical fight. That, Mike obviously, from the representative was younger, and then he beat him up. He beat up the defendant, at least at one spot. The defendant ran away from it. That's where he ended up on 3rd and Merton, and the victim in this case pursued him there and came at him again. At which point he pulled out a knife and thinking runs into it, or he obviously did more than just run into it. He because of the autopsy report, there were defensive type wounds on the victim. But I guess my question is, why wouldn't this be either manslaughter, either voluntary or involuntary, under those circumstances? Rather, I guess where we getting the second degree? Because you still have to have that intent to kill for second degree. You don't have to have it for manslaughter.
That's right.
Okay, and, I guess I'm kind of talking through it as I'm thinking through it as I'm talking through it. But, the heat of passion type argument, I think can go both ways. That can go to second degree or it can go to manslaughter. Self-defense doesn't really apply to the extent that it is the defendant that introduced the weapons into this. However, it does apply to the extent that they already had one fight, he got beat up. He ran away from it. He took himself out of the situation. And now he's not the aggressor. The deceased is the aggressor. The deceased follows him over here and then goes at him again. I guess, I think you get the gist of
I do, Your Honor.
my question is really.
Yes, Your Honor. In my response, I'll just split it up, I think, as the court has as well, regarding first the self-defense. Certainly the people who had the burden at trial to show beyond a reasonable doubt that there was not a fear of immediate serious injury at the time. And certainly in today's hearing, I don't think outlined that the defendant at any point had a fear of serious injury, either that he would be killed, sexually assaulted, or severely hurt. And I believe that would negate the self-defense claim, and that would be a requirement for it to be legal self-defense. Now, as it relates to the distinction between the manslaughter and the murder too, ultimately the mens rea itself is very similar between the two. The difference, as this court mentioned, was the intent to kill. And ultimately, I would argue that the medical examiner's report does outline multiple wounds with the knife, which would suggest at least multiple swings or what have you, which would illustrate an intent to murder, regardless of if it's a specific intent to kill, which would be murder in the first degree, or just an intent to commit, not intent, but the act committing would be great bodily harm. And certainly the final swing being through the chest of an individual, and as the ME's report lays out, penetrating the heart with severe bleeding in the interior cavity, would at least suffice that this intentional act of stabbing a person in the chest area would rise to the level of the intent required to show probable cause for murder too.
Well, Judge, I know you know this area of the law very well. I don't want to repeat things that you've said or tell you things that I know you know, but the postmortem makes it pretty clear there are other injuries. But the other injuries, I can't say that we can necessarily know they happened at this fight, the second fight, the first fight, or what happened. And I can't know that they happened with a knife. We're talking about other injuries. They're abrasions, is what they're called, and they're not termed, knife wounds. And when people are fighting, or when we have a man that may just get into fights a lot, he ends up with abrasions. He has scratches. He has them on his neck. And really, I suppose, on his hand is where the only other spot that we could maybe attribute to a knife, where there's an injury that could be attributed to the knife. No, I don't see how this isn't. He wants no more. I don't know how anyone, particularly the prosecutor, can say that he didn't think he was in mortal danger. Okay, we know he got beat up and to the point where he ran away. And people don't like running away. They get into fights and they want to win. And to run away is so cowardly that people just rather take it and fall. But no, he was scared. He had to remove himself from that spot. He had to go. And we talked about the gentleman who's dead now as being younger. He was more healthy, but I mean, we didn't get all of that. But we did get that he was younger, and then he chased my client down. And the initial blow, or at least the most significant blow from the knife, we only have on the record that the significant blow was he ran into the knife. Now, it's perfectly clear that my client has a knife and he puts it out. He's like, look, okay, I got beat down. You're back for more. How much more can you beat me before I'm gone? So he's not going to go through that again. And he sticks a knife out to show him, look, I'm serious. I'm not going to get hurt. He's using as much force that is necessary to prevent him from being harmed in a manner which may not necessarily cause him to die, but it's in a manner that clearly could cause serious impairment, serious injury. How long is this other man going to beat on him? It's clear that if he chases him down again, he's going to beat on him until he stops moving. That's the only thing that my client could be thinking. He's not using an alternative defense. That's not his intent. His intent is, I have to be safe, and I have to show him I'm being safe. And then what happens? The man runs into the knife. Maybe he didn't see it. Maybe he did and thought he would be able to avoid it. I don't know, but on the record, we only have that he ran into the knife. That's what's on the record. So, yeah, if it's found over, I think it certainly can't be higher than manslaughter, but I don't know where my client's intent is in any way to harm. He is using the necessary force to prevent himself from being harmed. And we know how badly someone can be harmed with fists, the hard surface of a street or sidewalk. Unfortunately, we live in this world where we see this all the time in these courtrooms. And so it's something that he had to finally resort to, and that was to show the knife. And then the deceased runs into it, and that's all we have on the record. And so for those reasons, I think the matter, this is a dismissal. My client used as much force as he needed to prevent himself from being beaten to a point where he was no longer able to move. Because when he was able to move, he was chased down. And he got chased down by the man who ran into the knife, which is all that we have on the record about what happened with the knife and the chain. And I hope that you just listen to me.
You vote.
Your Honor, I would just point out that I believe the self-defense argument itself would be question of fact or prior event. And at this stage, I don't think it meets the probable cause that was presented today. So I would ask the court find over to the court on the charged offense murder second degree. Thank you.
Alright. We're going to heard the testimony argument plans as follows. First one, initially, Officer Marianne Mitchell testified that she responded to a road for 757 Covington Drive, which is called frequency down on the grass, with shirtless during bleeding. Her Sergeant Matthew Dennett, he testified that the Officer DVD, homicide division, 24 years, he moved to the scene, interviewed the defendant. The scene was at Burton and Third. He went to the apartment after a search warrant was executed. He interviewed the defendant on October 28th, approximately 11 o'clock a.m. at the DDC. The court found that it received, understood, voluntarily waived the constitutional rights and made a statement. Basically, the statement was that he and the deceased, referred to as Mike, got into a physical fight. That he then, that the fight started in one area, about a block or so away, that the defendant, after the worst of that fight, got and ran away. The deceased then pursued him to Third and Merton, where the defendant produced a knife and stabbed him, or he ran into it, or not quite sure what happened. Also, the defendant had been drinking on that day. But the fact that there is a self-defense claim here, I mean, it makes it automatic question of fact. It depends on what the ultimate trier of fact wants to believe. And it could go either way. I mean, it could go, someone could believe that he, pulled out the knife with the intent to kill this man and did so. Or someone could believe that he was defending himself because he thought he was in imminent danger. But he already had been beat up once and was about to get beat down again. But that has to be left up to the ultimate trial. So the court's going to bind over, find that the felony enumerated as a plain warrant. Discharge the defendant. So we filed over the Wayne County Second Court Criminal Division for arraignment on the information. March 2nd, 2021 at 9 o'clock.
I'm sorry, is that on the murder charge?
Yeah, I'm buying all of them.
Okay. And the date was?
March 2nd.
Yeah, oh, you want?
All right. So the next one, take good care.
I'm going to try.
Which case is this? Which case is this we go?
Mr. Marino?
Okay,
Are they out there?
so they're gonna bring him up. That's the next case we're gonna do, right?
Yeah, are they out
Yeah, well, he's downstairs. He'll be.
there? Is the attorneys out there?
Yeah, everyone's here. Everyone's
Bring
here.
them in, bring them in.
They're here already. They're here. We just gotta wait for the.
Oh,
Oh, they got to bring him up.
where's the defense attorney?
Defense counsel at Marito.
That's a, oh, that's a police officer. So,
On
Is he out
Zoom. This was the one.
oh, yeah,
Nine
right.
five-
Yeah, okay, I didn't think
Yeah,
that.
this is the one that was on Zoom, I think, right?
It was. And then
Oh, that's Michael, Woodyard.
Yep, and then I had called, I was gonna do it on Zoom, you had said, but then I was like, I'm already here, I might as well just come down.
Okay.
Oh,
Thank
you
you.
finished right on time.
Take care, Mr. Cooper.
Okay.
Hold on, this is Bob Reed.
Woodyard? We can go on Zoom, I'm gonna do it. Yeah, something about him. You said Mr. Woodyard's gonna be on Zoom?
Yes, that's what he had indicated, he was appearing on Zoom.
Hey, why?
Because I would be asking for an adjournment based on my witnesses' unavailability.
Oh, yeah.
And if the court was not inclined to adjourn, then it would be discussed and not be pulled forward. And so I think that he intended to appear on Zoom.
All right. Gotta get him on.
If you would allow me to step up for a second and give him a call and just make sure. So, thank you.
This came to mess with that. Parent or something got sick or something.
Oh, he says he's logging in now, trying to put on another Zoom.
Yeah, something.
Well,
I almost forgot that my
Oh, yeah. Right.
oh, is he on?
Yep.
All right. Calling case number 21-55286, the people of the state of Michigan versus Deshaun Marino. Defendant is charged with count 1, homicide, first degree premeditated, count 2, weapons, felony, firearms. This matter is scheduled for examination.
Good afternoon, Your Honor. Ashley Chaffone on behalf of the people, P75922.
Your Honor, good afternoon to you and good afternoon to your staff. My name is Michael Woodyard. I'm appearing on behalf of Mr. Delshawn Bomarito. My P number is 64612. And Judge, please accept my apologies for my tardiness. I had a case with an interpreter that seemed interminable, and I apologize.
All right. Okay, where are we at?
Judge, today's the date and time set for preliminary examination at 2:15. However, just prior to today's hearing, my officer in charge is present in the courtroom today. Police officer is ARNTSON. Received a phone call from my complaining witness in this case, or one of the civilian witnesses, Ms. Hudson. She indicated that her father died unexpectedly. She's been at the hospital for the balance of the day today. And because of that, the people are not able to proceed. I would be asking the court to find good cause for an adjournment. People have requested no adjournments up to this point. It would just be very brief if the court would allow.
Anything you want to add, Mr. Woodard?
Your Honor, I leave that request to the court's discretion.
All right. Court's going to find good cause to adjourn this matter.
Thank you, Judge.
How many witnesses do we have?
Just one.
We do this on March 26th at 2:45.
That would work for
Mr. Woodard,
Judge,
that
you
works?
said, yes, you said March 25, 25?
No, March 26th at 2:45.
Okay.
Am I, please, Your Honor?
Yes, Judge.
Hold on, your client wants to say something.
I was wondering, Your Honor, if I could get a bond so that I may see my son. And, he was on for this time period until March. Please, Your Honor.
Right now you're charged with premeditated first-degree murder. There is no charge that is higher than that. None.
I understand, Your Honor.
Anything you want to add, Mr. Woodard? Your client is asking for a bond.
Your Honor, I guess the only thing I would ask, Judge, is perhaps in the meantime, if the court would ask your probation department to do an assessment of Mr. Bomarito, if that would help the court, but I wasn't prepared to make an argument on bond today.
All right.
Please, Your Honor.
Well, I'm not changing your bond right now. What I will do, though, I'm going to refer this matter to DSU, which is the Defendant Screening Unit, so I can get more information on you. And then allow you, the attorney, to readdress the issue then.
Martin.
Huh?
Martin.
Well, as soon as we get the report. It shouldn't take but a week or so to get the report. It shouldn't take but, it should take a little over a week to get the report. So someone from DSU is going to contact you. They'll ask you for certain information, like where you live, et cetera, that kind of stuff. And they'll go verify that information with people that you give them, and we'll take it from there. All right? Okay.
Thank you, Judge.
Thank you, Judge.
You're welcome.
You must have a tail.
Thank you,
must have a
Judge.
tail.
You're welcome.
Did I get, wait a minute, is your P number 64612? No,
Nope.
775.
75922. I'm Ashley, by the way.
75.
922.
Oh, so it's 922.
Yep.
Ashley.
Yep.
All right. Thank you.
Thank you. Have a good day.
Yeah.
Thank you.
I can't read my own hand. This needs a DSU report.
Are we ready yet? Oh, okay. Mr. Brown, follow my partner.
Yeah, I need a picture. What is it? Mr. Brown?
Mr. Brown, sir.
Hey,
Okay.
I come out. All right, we're not doing this. Okay. Now we're on Brown. Brown has 2 cases. So, 59317. Calling case number 20-59317, the people of the state of Michigan versus Michael Brown. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
And good afternoon, Your Honor. Juvenile Screwdriver appearing on behalf of Michael Brown.
All right, you ready to proceed?
I'll go check in the hallway, Judge. It's all right.
Okay.
Unreadable.
Judge ready to play ball. You ready to play some basketball, I can see.
Stand up.
You play tonight, right?
No, we got a bye tonight.
Oh, that's right.
Play Thursday.
Yeah, that's okay. Wow.
Yeah, I think you have a heart attack. Bring you Thursday. You go
Is it? You said I could come?
Yeah, I can take it down there.
Is it half court?
No. Okay, yeah, wow, probably. We're gonna do Yeah, we caught a gun game.
Okay. My understanding that was set at 2:45.
The gun is 230.
The solid set of murder is before 5.
245.
These are marked the complete opposite.
Do you want me to call that one first?
Well, it's ordered what the judge wants to do.
Are you ready on the other one?
You ready on the other case?
Pardon me?
Are you ready on the other case?
You already checked for that one, Judge. Let me go look. He's not gonna go far, he went my way. Okay.
Okay. Right. Okay. You can sit right there. Oh. Okay.
All right, what are we doing?
Okay. So we'll all check. Not yet, because.
Oh,
I
yeah.
don't know how this got, it wasn't even mine, right? It somehow got transposed.
So are we calling the other
Can we
one?
call the other case 59037? Is that okay with the court?
All right. Calling case number 2059037, the people of the state of Michigan versus Michael Brown. Defendant is charged with count 1 and count 2, assault with intent to murder. Count 3, weapons, firearms discharged from a vehicle. Count 4, count 5, assault with intent to do great bodily harm, less than murder or by strangulation. Count 6, weapons carrying concealed. Count 7, assault with a dangerous weapon, felonious assault. Count 8, assault with a dangerous weapon, felonious assault. Count 9, count 10, count 11, count 12, count 13, count 14, count 15, weapons, felony, firearm. This matter is scheduled for examination.
Good afternoon, Your Honors. Prosecutor Blackwood for the people. I do have Officer Ronald. Why is the officer charged seated in the gallery, Judge?
Judge, Giles appearing on behalf of Michael Ronald, ready to proceed.
Brown, state your name for the record, please.
Michael Brown.
Thank you.
Some of the people that are going to go forward, if I may just make a record, with regards to our efforts. Yesterday, I did speak with the witness on this, Ashley Carter, and spoke with her, gave her the date, time, and location to be here. She indicated Delon is her husband, DELON for the reporter. And I gave her, again, a date, time, location for the exam. She indicated to me that she didn't want to go forward with the matter, but she did indicate that she would come down today. She is not here in the hallway, we just checked the hallway. I have officer charged, if I may just have her make a statement on the record to her efforts.
Sure.
Okay. Can you give your name for the recorder, please?
Officer Ronald White.
And officer, can you tell the court basically your efforts to advise and try to get Ms. Carter and Mr. Delon Johnson?
I did not have a good phone number for Mr. Delon. I did try to find a phone number for him via our clear investigative tool. So, Ms. Carter, I did have 2 phone numbers for. I left voice messages on February 1st, February 15th. I attempted to deliver the subpoenas on February the 18th. One address for Ms. Carter that she left me, the individual that resides there stated Ms. Carter does not live there. I made another location, which was a family member's house. I handed the subpoena, said, can you get this to her? She said, okay. I have one last address for her with negative results. I did find a phone number for her via the clear investigative systems the other day, Tuesday, I believe. She was unsure what she wanted to do. I advised her, please go pick her up. She went to court, the following day. So that's where we're at.
Thank you. So we can proceed.
All right, you can have dismissal officer, just maybe fill out, dismissal form, please.
You got it. Thanks. Right here. Thank you. Thank you very much. Okay.
Thank you.
Somehow we're, whoever wrote it down, got the times transposed in different cases. All right. Yeah, sorry about that. Okay. All right.
Okay, Judge.
This one, that's not cold. It's called tracking.
No.
My bad. Oh, really?
All right. So is that your doing that COVID sheet there? You gotta sign it. Hey, you gotta get Kenny's name on here too.
For what?
The COVID sheet.
Huh?
That sign-in sheet.
For what?
They got everybody's name on there for tracking, case tracking. You know, COVID.
Yeah.
They got my name on there too.
They put your name on it? Why?
Because I'm in the court.
Oh. Oh, they probably have a different list for us.
Yeah, we don't have to like put the judge in the court.
Court clerk's name on there.
Shut up. You gonna bring him back out when we call it?
Yeah.
I've been slipping here. You ain't saying nothing.
Was he that? Was he that guy?
I've been slipping.
Yeah, thank you.
Y'all remind me to spray after that.
We got quite a few.
Huh?
We got quite a few. Man. You tell me. And one old you.
I like the smell of that.
Say it again.
I like the smell of that. Did you get it? Oh, here's the attorney's copy.
Okay.
Wait a minute, you're not Sophia Curry.
Yeah, that's what I'm saying.
Counselor.
Hey, Cujo.
Yeah.
Counselor, are you standing in for Ms. Curry or is this your case?
No, this is my case. Like, she called me yesterday. I think she stood in for me at one of the PCCs.
Oh,
And she said somehow it showed up with her name on it.
So real quick, Mr. Moody, right?
Oh, whoever was in here for her.
Yeah, no.
Maybe she didn't say.
Yeah, right. So it's funny, so I was talking to
Maybe.
my father after.
I wasn't here, so it wasn't me.
Sorry.
You're 71963, right?
Yes, ma'am.
Okay, so do you want me to change the prior one?
Please. Yeah, I was appointed on it.
Yeah,
I think it was
I
like
did.
back in August or something.
So on 2-5, let me change that because they got her as the attorney. 71963. I am gonna put her. So let me ask, do you need a ROA for this?
I can just print it later. It's fine, because you guys put it out. I guess the other one. It's not 245.
Yeah.
He's saying it's also might be on their way or something. So I don't know. He's gonna wait for him. He's not just on the way. He wants to hold it. Since it looks like they're not ready anyway.
What's the bond on the next page?
The other one was low.
You said what's his bond?
Yeah, on the CCW.
1,000 personal.
Oh, okay. Why is it locked up? What's the bond on the other one?
The other one was pretty high.
Oh,
But you know what's crazy is they brought him in on this CCW.
Yeah, the other one was 500,000.
The whole basis of the CCW is they say they're making an arrest for that A1 warrant, and then they find the gun on him. They bring him in here, get him arraigned on CCW, he gets personal bond, he gets released. Then like 2 weeks later, they re-arrest him on the A1.
Okay, this is.
Forgot the name of the officer.
Is that time?
Time out. That's a dick.
That's, Irene.
Thank you. It's 26.
Mark 26.
It'll be here though.
ready?
Yes, Judge.
The officer here.
Oh, you-
Recalling case number 205. Oh.
No, I won't take it to court.
Oh, yeah.
Always.
Go back. Damn.
You gotta check them out. You took, you took them. I thought you took them.
Come on. Oh, sorry.
Ready on Michael Brown. Recalling case number 2059317, the people of the state of Michigan versus Michael Brown. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good afternoon, Your Honor. And good afternoon, Your Honor. Jimmy Okuja appearing on behalf of Michael Brown. Your Honor, we had initially set the matter both for exam because of his other case. But given the outcome of the other charge, the other case, Mr. Brown wishes to waive his statutory right to preliminary exam in this case.
Right here.
Oh, you got it.
You understand, so state your name, please, for the record.
Michael Brown.
Ron, you understand that you have a statutory right to preliminary exam with a statement show by probable cause crime was committed?
Yes,
Probable cause you had something to do with committing that crime.
Yes, sir.
Anybody promise you anything or threaten you in any way that you waive your right to preliminary exam?
No.
You waive your right freely, voluntarily, after having the opportunity to talk to your attorney about it.
Yes.
You sign the waiver of examination form?
Yes.
All right, qualified freely and voluntarily waive the right to preliminary exam that is bound over Wayne County Circuit Court Criminal Division for arraignment on information. Be March 9th, 2021. And matter of fact, you don't have any other holds, does it? Oh, let me make sure.
No, it's good. That's it.
You got a person on.
Okay.
You get out.
All right, thank you.
I'll call your dad.
Okay, thank you.
Hey, Steve. We're good, right? Okay. I think I saw that thing. Okay. Okay, what's the other guy? Riley. What's the other guy's name I gotta bring up?
Johnson.
Johnson?
Timothy Johnson.
Yeah?
Yeah,
Yeah, he said it.
Weapons,
No? That's all, just got the one case?
weapons carry, oh, I just have to look at the file. Weapons, felony, firearms, weapons carrying concealed, weapons, firearms, possession by a felon. Habitual offender. Personal, 75 minutes. You must have another case. Maybe you got something.
Oh, he might have been one of those, you got the best one, he's on the road, pick up a new case. They were,
Oh, yeah, here's the writ right here. Duh.
That were,
For Johnson.
yeah.
Did you do the writ, Moody?
No, I don't, I'm looking for one in our files, I don't see one.
Your Honor, how you doing?
Somebody did it.
Your Honor, I'm in a,
I got a copy.
for Judge Gant, and she said to ask if she could convey to Your Honor that I have 1 minute to finish up with her on Zoom.
The writ, it was done. He's here.
all right.
Thank you, Your Honor.
Okay, cool.
Okay.
Yeah.
Judge Gant, you got permission.
I didn't have the file last fall. I'm looking for it.
I'm just happy it went through.
Yeah.
Michael Brown's BOI case, 39?
Yeah.
It is 39?
39, yeah. It'd be opposite.
Okay.
You still going next door too?
Huh?
You still going next door?
Yeah.
Yeah, let's
so-
go.
You don't think about whatever needs that he gets on character. Then get rid of the courtroom. Holler at somebody.
I walked past the court and heard the verdict. I guess he was scheduled for 8:30, comes in at 8:45.
Is there an attorney here for
Lawyer,
Mr. Johnson? Yeah, is there an attorney here for Mr. Johnson?
No, he came in and said you don't want to.
Okay. Okay, so I'll just put him in a.
Yeah.
He knows that.
But I also heard that he had to get with somebody in the hallway. I guess that's not what we heard. Yeah, it sounded like he was in the hallway at the time of this thing, but someone else.
So he did show up.
his staff was ready to have the officer went out in the hallway to ask them to be quiet. They wouldn't listen to him, so he had to go out there with them, that kind of loud.
Yeah. Why can't you all let it alone?
I'm sorry, what did you say?
Just like Rodney King, why can't you all just be alone?
Excuse me. Hey, can I get some paperwork for Dorothy?
Bro?
Dorothy, that's the first one we did.
With rain heavy on.
What happened?
I know someday, I know someday that's gonna be a vacation. I know. So rather bring it back in.
When I realized what I realized.
My guy's here.
I experienced a mild.
Oh, that was quick. That's the attorney.
Let me get in there. Yeah, please. I can, it means right here.
It's just a mild case. different.
You got to go.
The way I used to. So.
Happy birthday, how you doing?
Hi, how are you?
Good to see you.
Good to see you too.
Hang on, better times are coming.
I hope so.
How are you doing? Good. Also, hang in there.
I'm a partner.
All right. How you doing?
Ready on Timothy Johnson. Calling case number 20-62202, the people of the state of Michigan versus Timothy Johnson. Defendant number 1 is charged with count 1, weapons felony firearm. Count 2, weapons carry concealed. Count 3, weapons firearms possession by a felon. Habitual offender for notice. This matter is scheduled for examination.
Good afternoon, Your Honor. Prosecutor Ronald, people.
Good afternoon, Your Honor. Attorney Brent Jaffe on behalf of Timothy Johnson, Your Honor, present. Ready for examination. P81818.
You guys might go check the hallway for my, please.
Johnson.
Timothy Johnson.
Thank you, sir.
Sit down.
All right, if I can speak to that.
Yeah. Messages. Judge, I did go in the hallway, thank you for allowing me the moment to do it, I did not, I called the trooper's name out, Martinez Alexander, Alexander Martinez rather, I'm sorry, for the reporter. No response, Judge, we cannot proceed without evidence today. We would ask for the record.
Your Honor, would you motion the court for a dismissal at this point?
All right, Madam, dismiss without prejudice.
Sit down, done. I think you're ready.
Come on, sir.
Okay? All right, thank you. Yeah, please do. All right.
Need a dismissal, counsel. Can you give him a dismissal?
Madam Clerk, would I be able to give my client a?
Huh?
And I find a copy of the dismissal form.
Yeah, I'll take it.